Thank you. I'm going to start again. Thank you everyone for coming. I'm Christoph Bondi. I'm a partner in the International Arbitration Department here at Steptoe and Johnson. And we're delighted to be co-hosting this launch event with BIICL, with whom we've been collaborating over the last kind of year and a half in the development of this study, which we all encourage you to get a copy of and look forward to your comments on. Also, this event is being recorded and will be available as for rebroadcast afterwards. So we encourage you to disseminate it to anyone you think might be find it of interest. Steptoe is active in international arbitration in the sense that we have about 10 partners here in the London office who are whose practice focuses substantially or exclusively on international arbitration. And in particular, 3 of us who are almost exclusively working in investment treaty arbitration. And we have a number of associates, including my colleagues, Michael Lee and Alexandre Genet, who are my co-authors in the study, will be speaking here tonight. And we're lucky to have Eric de Brando and Maria Fogestam Agios, who's come from Sweden, and from Belgium for Eric. We're delighted they came, and we thank them for the work that they've done to review our submissions and our study. And I'm sure that made a significant impact on its final form. So without further ado, I wanted to pass over the floor to Jarek Krivoy, who's the head of the Investment Treaty Forum at the British Institute of International and Comparative Law, to introduce.
Thank you very much, Christoph, for hosting this event. And we were just thinking about the previous event which we hosted here. It was in 2020, just before COVID. And at that time, it was very novel to record things or to broadcast things, and things have changed so much over the last few years. It's a pleasure to be here, and it's a pleasure also to witness the successful result of our cooperation between BIICL and Steptoe. This empirical study on performance requirement prohibitions in international investment agreements. It took us over a year to produce this report, because first it always takes some time to identify the issues which we need to focus on, what to write, what is not less essential to write. So the idea of this report is to present in a relatively simple format the rather complex concept of performance requirement prohibitions in international investment agreements. And this is a result of a significant amount of empirical work as well, analyzing many international investment agreements and other sources. We will know much more about performance requirement prohibitions by the end of this event. But the general idea is that these requirements can be included either as condition precedent to states' authorization for an investor to actually enter a particular country, or this can be conditions for an investor to comply in order to get some benefits from the host state. And in many treaties, they try to prohibit those requirements, such as local content requirements or expert performance requirements, because they may have some negative impact, negative effect on trade and other implications. We'll talk more about those later. For those of you who are here for the first time at Investment Treaty Forum events, we are part of the British Institute of International and Comparative Law, and the Investment Treaty Forum tries to bring together representatives of law firms, of governments, of academia, barristers, and other stakeholders to discuss international investment law, investor-state dispute settlement. We actively participate in the activities of the UNCITRAL Working Group 3, contributing to reforming the system. And actually, Christoph will go to Vienna later this year on behalf of BIICL. And Christoph also joined recently the advisory board of the Investment Treaty Forum. So we're very pleased to have this collaboration with Steptoe. And my role today is more of a logistical one, because I'm not one of co-authors of this paper. However, I'm in charge of recording. I'm in charge of presenting the speakers, and also please let me know if you have any questions about the Investment Treaty Forum later, or about BIICL. There are some materials about the Institute there on that table. And as I understand, there will be the final version online of this report later this week, which you will be able to share online. But this version essentially is 99% the same as the one which you will get. So the way how we are going to do it is first to first the co-authors will introduce the study and its key findings, and then we will have our esteemed reviewers who gave comments on earlier drafts of this paper. They will share their thoughts about this paper, and also more generally on related topics. So let me, so Christoph, would you like, shall I ask Alexander to speak now? Yeah, so Christoph hasn't been properly introduced. He's a partner with Steptoe, and he's been here for a while already. Although I knew Christoph from before, he has degrees from the University of Ottawa, University of Cambridge, University of Toronto, and he served for over 8 years as senior counsel and deputy director at Trade Law Bureau of the government of Canada. Yeah, it's been actually 6 years since you've been at Steptoe, so it's quite a long time. The next co-author of this paper is Alexander Genet, who is senior associate with Steptoe. He studied law at the University of Ottawa and Leiden University, and by some strange coincidence, his PhD dissertation was devoted to performance requirement prohibitions in international investment law. So he is now an associate here, and prior to that, he worked at another law firm in London, and also clerked for Judge Tomka at the International Court of Justice, and also worked for the government of Canada in the past. Over to you, Alexander, and if you could please attach this microphone to your lapel.
Thank you very much, Jarek. Thank you very much, Christoph. I'll just say a couple of words briefly to introduce Michael Lee, who's also a co-author of this study. Michael has been with Steptoe for 2 years. We collaborated closely on preparing this study, and we look forward to discussing its contents with you today. So a few words of introduction. We'll start very general, but I promise we'll get specific, and we'll provide real-world examples very quickly. So this is just one broad, somewhat abstract definition of what is a performance requirement, but just bear with us and we'll get real-world examples very quickly. So the way that UNCTAD, in a paper that was published in 2003, defined performance requirements, it's essentially an economic concept, right? So we have to start with a very economic and general definition. The way that UNCTAD defined it was as stipulations that are imposed on investors, which require them to meet certain goals with respect to the operations of their investments in the host country. And so it's the host country essentially dictating how investors should run their activities. There are, as Jarek explained in his introduction, 2 main categories of performance requirements, and that is something that you will see as well in the provisions that prohibit these performance requirements that Michael will discuss a bit later. There are 2 main categories of performance requirements. Some are standalone, which we would refer to as mandatory performance requirements, and they are conditions that apply to making, operating, expanding an investment. So either you comply and you get to do the investment activity that you want to engage in, or you don't comply and you don't get the authorization. But you also have advantage conditioning performance requirements, which the states will often attach to a certain benefit, advantage, incentive, subsidy. Call it however you want. The terminology is generally advantage in investment treaties. And so it will be attached as a condition for the receipt of such advantages. Those are the main categories of performance requirements. Now, why why states adopt performance requirements. Before we look at the prohibition of them, it's interesting perhaps to ask ourselves, why are there performance requirements? And there are three main objectives that states seek to achieve when they impose performance requirements. The first one is to increase exports on the one hand and reduce imports that are associated with investments. So you'll see there's a running theme of balance of payment concerns on the part of states when they impose these measures. Up the exports, reduce the imports, improve your balance of payment. The second objective is to increase the use of local inputs and resources that an investment uses. And here it's to increase economic activity in the state in which these foreign investors operate. You want the foreign investors to mingle, to interact with local economic actors, and you want them to use the resources locally and not import everything they need for their production. And the third objective is, as part of that process of economic activities of foreign investors, you want them, these foreign investors, to introduce new processes, know-how, technology, research and development activity that they have access to outside of the host state into the domestic economy of that host state. So those are the three main objectives that states seek to achieve with performance requirements. And we'll get a bit more specific in a minute, and you'll see the types of measures that they will impose to achieve those objectives. Now, why do states seek to prohibit those performance requirements? That's the flip side, and that's essentially the main topic of this study. So prohibitions of performance requirements are investment treaty provisions that seek to curtail the ability of states to impose these types of measures, performance requirements. There are two main categories of objectives that states seek to achieve by prohibiting performance requirements. The first category is investment-driven, which is why you see these provisions in investment treaties. But there are also many trade-driven reasons, which give this hybrid nature to performance requirement prohibitions. So they serve investment objectives, but mainly also trade objectives. And that's why they sit awkwardly sometimes in investment treaties. And we'll discuss that in a bit more detail today. The investment-driven objective is fairly straightforward. It's to prevent states from imposing government-mandated practices that supersede the investment's own business-as-usual decision-making, right? So investors are generally better placed to run their own businesses. They know the costs, they know the benefits, they know how to make a profit. When states come in and impose their views onto investors' activities, it can create frictions, losses, and you can see why perhaps prohibiting these measures can be in the interest of some states whose investors operate abroad. That's the investment side. But although we're talking about investment treaties, and although there are many investment-driven objectives for these measures, they also have trade objectives and trade-driven reasons for being adopted by states. And there are four main categories that we can identify. There can be more than one reason that is aimed at being achieved by a PRP. I'll start referring to PRPs. It'll just save me some time. So the first one is increasing foreign market access for foreign investors and also for exports that are from home states. And I think many of us will be using that terminology, home states, host states. Home states essentially mean the states whose investors go abroad. So in a bilateral investment treaty, a state may wear both hats, but often it'll have a role of either capital exporting or capital importing country. And so they will want their exports to increase, and they will want access to the other states' market to increase. And by increasing their foreign investment abroad, the idea is that these foreign investors will likely import from their home states' corporations because they have networks with them. They know them, they know the quality of their products. So they'll use those inputs into their own production. That makes exports of this home state go up. And so that's why there's a trade objective that can be achieved by prohibiting these measures. The second one is a corollary of that, and it is to eliminate import restrictions on the part of host states. So if you go back to the idea of what do states try to achieve with performance requirements, one of them is to reduce imports, right? They want to increase their exports, reduce imports, improve their balance of payments. That's why other states will seek to prohibit these measures, because actually they prefer that their exports go up, which means that the imports of the other state go up. which is not necessarily in the interest of the home state, but it's a concession that a lot of home states are willing to make as part of the bargaining process of negotiating these treaties. The third objective that prohibiting performance requirements can achieve is to prevent the compulsory export of production that arises from investors in a host state. So some host states will try to protect their domestic economies from foreign competition. And you can have some economic benefits of having investors operating in your country, but not competing with local actors. And all they do is essentially export their production outside of the country so as to not disrupt the economy too much. Of course, that's a calculation that makes sense in some instances, doesn't in others. And the flip side of that can be achieved by prohibiting performance requirements is the exact reverse. Say a country, a host state, is unable to have ready access to certain products or certain inputs on its domestic market because it's not attractive enough for investors to sell their production on that market. Well, a host state can decide to essentially trap an investor's production onto its own domestic market by preventing the export of the production. So that's another goal that prohibiting performance requirements can help achieve. This is perhaps looking into the future. We don't have a crystal ball, but we think that there is valid evidence to make that suggestion. We believe that there is a chance that PRP disputes will arise in the future. And why do we say that? Well, I think we can all agree that there's a bit of a reversal of the pro-liberalization, free flow of investment consensus that prevailed in the 1980s, 1990s, maybe even early 2000s due to a number of events that have occurred since then. And this has shifted the approach of states towards economic activity from laissez-faire, non-interventionist, to proactive interventionist. Some of these events that have intervened since, say, the early 2000s include the global recession, the global financial crisis, pardon me, from 2008, other instances of recession, concerns of deindustrialization, losing your industrial base or industrial erosion, the COVID-19 pandemic, of course, that changed a lot of things. And of course, it manifested itself in supply chain disruptions. And therefore, now there are concerns of increasing the resilience of supply chains, which means having everything locally, everything readily accessible, have economies that are more self-sufficient. And so to do that, often you need state intervention to kind of reverse the way that production has been developed over the last decades. And finally, climate change, which is often a topic that leads to more state intervention, so as to entice, encourage, incentivize production, processes, and products that are more climate friendly, that lead to less greenhouse gas emissions. And so these factors have led to more interventionist state measures into the economy. And we believe that these occurrences of additional state interventionist measures will lead to tensions arising between those and often previously existing commitments of a lot of states not to adopt such measures in their PRPs, in their IIA networks. And just after New Year, we had what I saw as a gift when I saw it come out. I was quite excited. An IMF working paper titled "The Return of Industrial Policy in Data." And to me, that spoke very vividly, very quickly. And when I read through it, noticed that it kind of validated our crystal ball assessment into the future. So there is a massive resurgence of industrial policy type measures that can be quantified. These economists have started doing that. They've created what they call the NIPO, the New Industrial Policy Observatory. And they will start monitoring measures that in many instances amount to performance requirements. And this was a category of measures that before flew under the radar because it's often, as I mentioned, trade driven. And so it often appears as an uninventoried subset of trade policies or trade measures. So it gets buried in trade driven databases, but no one's looking at it from an investment perspective to signal these measures. States are quite vigilant about trade policy measures because they have WTO state-to-state obligations and they have notification requirements. They have to discuss these measures quite often at the WTO. So that's monitored, but the investment side, not so much. And so now we have efforts that have begun in earnest at the start of this year to start inventorying them. And when you look at the types of measures that they are pointing to as instances of industrial policy, a lot of these measures would qualify most likely as performance requirements under investment treaties. So just to mention a few real world examples, as we promised we would engage in a bit to give a bit of flesh around the bones. Some of the measures that they singled out included export barriers, and they noted, the economists, not us, we're not making a legal qualification of these measures, but for example, China's export control measures regarding targeted drone-related products, and they amount to export barriers, so they would fall into categories of export performance requirements, and this is from January 2023, so very recent. Import barriers, there the economists tracked a measure from India of January 2023 that requires import licensing requirements for laptops, computers, servers. So there as well, that's a likely performance requirement. Export incentives, as we mentioned, advantage conditioning performance requirements. Here, the economists identified Brazil's September 2023 loans to aircraft manufacturer Embraer to support export operations. Some of you will remember the Bombardier Embraer saga from the 1980s and early 2000s, or the Airbus Boeing saga that possibly is still ongoing now, almost 20 years later. So this is another example of something that would amount to a performance requirement. Another example that these economists tracked down were favorable treatment of local firms in procurement. And they point to US procurement measures of March 2023, so again, very recent, that favored domestic firms in government contracts for circuit boards. And finally, another example of potential performance requirements that these economists are tracking include localization incentives or requirements. And these included local content requirements in the US Inflation Reduction Act. And just to compare these types of measures that we listed as examples, real world examples, and the most commonly prohibited performance requirements in the provisions that we will start discussing in a few minutes, this is a kind of boilerplate list that are not all of them always prohibited by all PRPs and IIAs, but most of them will, and if not, at least some of them will be prohibited. So it includes local content requirements or local sourcing requirements, export performance requirements, trade balancing requirements, export controls or restrictions, technology transfer, licensing, and or local R&D, research and development requirements, foreign exchange restrictions and or earning requirements, investment localization requirements, domestic sales requirements, and product mandating requirements. And I pass the baton to Christophe. Yes, thank you. Thank you, Eric.
So I think what's really interesting about this topic is it's just one other illustration of these waves of policy from liberalization to more protectionist or interventionist policy over the last 40, 50 years. So you have in the early 1990s, as we've seen in our study, a real kind of push to start prohibiting these kinds of interventions into the economy or disciplining them at any event, to allow private actors to decide for themselves how they're going to organize their business, where they're going to seek their inputs, where they're going to sell their products, and so on and so forth. And so that was part of a much more general wave of liberalization from the early 1990s, reflecting in the WTO agreements, reflected in things like the adoption of the NAFTA and the rise of investment treaties during that period. And as Alexandre was suggesting, what you now have is, for the last several years, a rise of much more interventionist kind of approach to the economy, much more industrial policies, as the IMF study was suggesting, a sense of, well, you know, the state needs to intervene to get the right outcomes from investment. And what that creates, and what's of interest both for government officials, for academics, and for lawyers, is a kind of disconnect. I remember when I was working on the CETA, the negotiation between the trade and investment treaty between Canada and the European Union, and we had to go through a process of listing the European Union member states' non-conforming requirements against services and investment disciplines, including performance requirements. And that was something that at that time member states had not done. They hadn't kind of gone through and thought, and they had what we called the GATS epiphany, that they realized that a lot of measures that they had adopted that were on the books were actually not consistent with their existing, in that case, WTO obligations. And I think that what we've seen is that there is some of that disconnect here, where a new generation of policymakers and politicians are promoting certain kinds of more interventionist measures, and maybe forgetting what they've got in what they have in their existing agreements. And what you see listed on the slide are actually 3 of the most recent large-scale, multilateral international trade and investment agreements, which actually carry forward the legacy of that kind of 1990s and after performance requirements. So the CPTPP, which covers 11, soon to be 12 member states, a huge portion of the world economy, ranging from Canada, Mexico, Peru, Chile, Singapore, Malaysia, Vietnam, Japan, Brunei, Australia, New Zealand, and the UK has sought to join CPTPP as well. That has robust performance requirements. The US-Mexico-Canada agreement, which is the successor to the NAFTA, has maintained those requirements. And then the, in a sense, alternative to CPTPP, the RCEP, Regional Comprehensive Economic Partnership, again in Asia, again incorporating these requirements. So there's a kind of, if you will, kind of policy impetus that is still there, which is arguably at odds with the kind of rise of a more interventionist economic policy. And what we've seen from the cases, but examples as well, is that the range of industries that can be affected by performance requirements is really quite vast. There are cases relating to the extractive industries, which will mention renewable energy, car manufacturing, obviously one of those key manufacturing areas to economies, the commodities trade, IT hardware, and broadcasting. And these are all things that come out of real world examples. And I think it reflects the fact that the impetus to adopt these kinds of industrial policy measures are not really limited to any one sector. And can have an impact across many sectors. So to give a sense of some examples, there haven't been a vast number of cases to date, investment treaty cases about this, but several of these cases show that these provisions can have real teeth. And so my sense is these are some of these provisions, disciplines that are lurking in international investment agreements that could really come forward and be quite actively used if state officials, practitioners, and practicing counsel started to kind of put the two and two together. So one that maybe more well known from the Canadian context is the Mobile in Canada Award, relating to the adoption under in relation to investments in the oil and gas industry in Newfoundland of local R&D expenditure requirements. And I'm not purporting in the context of this presentation to get into all of the nuances and details of these agreements, or these awards, but just to show and some of those nuances are set out in our study, and I invite you to take a look in particular in Annex D. But in the case of Mobile and Canada, there was a first and then a second award, and I believe the first award was in the range of 17 million, and then the second award follow-on was in the range of, it was effectively a tax credit that was given to the value of $35 million. So it was a significant amount of money that arose. The next one that's referenced is local content broadcasting requirements in the radio industry. And I think this one, which arose in the context of a dispute with Ukraine, is interesting because it also illustrates the importance of states paying attention to the drafting of their performance requirements provisions in agreements, and thinking in particular about exceptions. This is a case that probably would never have been brought in Canada, for example, because we have an exemption for cultural industries. But there wasn't in this particular agreement, which is an earlier generation agreement with broadly defined performance requirement prohibitions. And so the case went forward. There was a trio of cases against Mexico, all arising out of the high fructose corn syrup industry. It was related to soft drinks. And there it was a differential tax treatment of goods, of products that contained or did not contain a local requirement. What's interesting, I think, about these cases is they show some of the subtleties of the application of performance requirements, in that it wasn't the treatment that the investor received, it was the treatment of other economic actors in Mexico who received a benefit that was conditioned upon the receipt of having a local content. And that was one of the things that was cited as a basis for the violation. But as we note in the study, some of the analysis there can be a little bit wobbly. So one of the challenges one faces with regard to performance requirements is also that, given the relative dearth of cases, and given questions one might ask about the analysis, there isn't in a sense a clear line of cases that one can see this is how they're going to be interpreted, and so that presents both opportunities and challenges. There was an earlier NAFTA case that was with regard to local content requirements applicable to the procurement of steel components. That was the ADF case, and there again, that was a case that showed the power of an exception, because the public procurement was conditioned upon local requirements, but there was an exception in the NAFTA to with regard to public procurement. Finally, there was a case relating to restrictions on gold exports. Where could the gold that was produced in the mine be sold? And the state in question was saying it can only be sold on the local market, where the value of the commodity was lower than on the international market. And there, the tribunal found that there was a violation of a performance requirement prohibition against requiring domestic versus international sales, and awarded damages. So these cases have shown that there are real world implications for these restrictions and obligations, and that given the particular policy context that we're in right now, there's likely to be more examples that arise. I'll just for a moment talk about why this is of interest for investors, because, as I say, in the context of shifting policy environments, as an investor, one has to be aware of, well, what rights do I have? Where can I push back on the policy that the state is putting forward? Is this part of the deal that this state negotiated with my home state with regard to the way my investment can be operated? And there are questions that might be raised with regard to state sovereignty. Why is it that the state should not be allowed to pursue its own industrial policy? And I think the right answer to that is for the state to consider the consistency of its own policy, and to think about what undertakings and commitments it made maybe 10 or 15 years ago or 20 years ago, and how those accord with the current direction of policy within the state. And that's why this is also of interest to states, because states really need to take stock. As a former government official, I know there can be a dearth of institutional memory, or really the need to make the rounds for what is on the books with regard to a particular kind of policy initiative, and to consider the consistency of that new policy with what's gone before. And the study that we put forward is basically just to give those kinds of investors and policymakers, academics, a kind of bird's eye view of, well, what did these look like? What are the differences between them? Is there any kind of classic expression in them? Should we be worried about completely different models, or is there some kind of convergence? And that's what essentially came out of the study that we provided. I'll pass the baton over to Michael.
you very much, Michael. Let me say a few words about yourself. Michael Lee is an associate here with Steptoe, doing primarily international arbitration work, and he studied law at the University of Sydney in Australia and did his LLM at UCL, where he also coaches UCL teams taking part in moot court competitions. And in the past, Michael also interned for the president of the United Nations International Criminal Tribunal for the former Yugoslavia. Michael, the floor is yours.
Okay, thanks very much, Eric, and thank you, Alex. I got 2 introductions. I feel very special, and thank you, Christoph, as well. And thank you both in particular for setting the scene and to describe the theory and the contents and also the continuing relevance of PRPs in investment treaties. For my part, I'm going to look at and focus on the methodology and data set and what we have extrapolated from that in order to provide a more systematic understanding of PRPs in investment treaties. And to start, I will draw your attention to the map that we've put together just to illustrate how we have sampled the data that we've used to found our study. The main focus of this exercise was primarily to gather a critical mass of investment treaties that we can analyze. And for that purpose, we have focused on 6 states, which we have selected partly to ensure that there's a critical mass. So we selected states which have sustained investment treaty practice, including investment treaty practice specific to PRPs. But also we wanted, to the best extent that we can, to have some geographical and regional diversity and representation. So as we explain in more detail in our study, which I encourage you all to read, we picked, for example, Canada and the US because they have sustained practice, in particular on PRPs, in particular in the form of NAFTA, Article 1106. We also picked, for example, France because it has a fairly unique approach to its PRPs as exemplified often in its past and perhaps present model BITs. But these are countries from what we'd call the global north, but we wanted to ensure that to be representative, we have some countries from what we'd call the global south. So hence, we've included, for example, Chile and India in particular, because it has a fairly notorious and well-known objection to PRPs, which date back to its role in the negotiation of the WTO agreement. And also, finally, Australia was included, probably because even though it's a geographical south country, it's considered for some reason a global north. And having looked at the data of investment treaties for all these countries, we have tabulated among them that there are a total of 528 unique individual investment treaties that we can analyze. That's a fairly large sample size. And it also represents, if we look at the countries' economies, they represent about 35% of world GDP from a few years ago, and we have no reason to think that has changed substantially. And when we look in particular on the issue of PRPs, we find that 206 of these 528 IIAs contain some form of PRP, so about 40%. If we break it down further by country, as you can see on the slide in front of you, what we see, interestingly, not that we're in particular looking for patterns or trends, but the only trend appears to be that it's very difficult to draw any particular trends, and to some extent, it is beyond the confines of our empirical study to make these qualitative observations about the issue. We just wanted to primarily focus on gathering data systematically and then constructing from there a typology of PRPs past and present which have been in vogue, which will be useful for investors and states to understand the issue. But just to elaborate on my comment about how it's somewhat difficult, even though we've taken a restrained approach, to draw out any trends. One may think, for example, that countries in the global north, which we have 4 of, may have a similar sort of approach or proportion of investment treaties which contain PRPs. And to some extent, if we look at the data on its face, we may be able to say that's particularly true for example, Canada and France, where it seems to be about 2/3, and also the US, where it's a plurality. But then if we pivot to Australia, which is also a global north, perhaps capital exporting country, it still has quite a few PRPs amongst its collection of investment treaties that it has signed and often ratified, but the proportion is much smaller. And to no one's surprise, India, with its sort of sustained objection to the notion of performance requirement prohibitions, at least in the WTO context, even though it's got quite a sustained practice of signing and engaging in investment treaties, it has a very, very small proportion of those that contain PRPs. So as I've mentioned, what we can probably extrapolate, bearing in mind we want to keep this empirical and systematic and data-driven, is that PRPs appear in a significant number of investment treaties among our sampled states, but we certainly can't say that they would appear in all of them or even the majority of them. But there's a fair chance if you pick up amongst a sample, a typical investment treaty, you should probably look for a PRP in there. And it would be speculation on our part to analyze in the context of a quantitative and data-driven study what are the factors that contribute to these variations, but we've suggested a few which may, for example, merit further research. So, for example, looking at each state's individual approach to trade and investment over time, that may inform an interesting study in the future. So having set the scene with the figures, and just to recall, we have 206 IIAs which contain PRPs in this sample, which is quite substantial for any study. I just recall briefly before we go ahead that there are two forms or flavors of PRPs. So we have mandatory ones, which are basically, as both Alex and Jarek have described, they're fairly standalone obligations, and chances are if the investor doesn't comply, it just won't get its investment approved, but it gets nothing in return for compliance. And then you have advantage conditioning performance requirements, which function more like a quid pro quo, and it's for the investor to weigh up, is it worth complying with them? For example, it needs to export more to increase indirectly the host state's foreign exchange reserves. Is it worth complying with that in order to get, for example, tax breaks and to relocate to that country for operations? And in our analysis, we have split our typology of PRPs to focus on mandatory ones and advantage conditioning ones. Starting with mandatory performance requirements, what we found in our study of the 206 investment treaties is that they essentially follow one of three main drafting approaches. The first one is what we've called the open-ended PRP. That's one of the earlier ones which were developed, and they're fairly characteristic of first-generation US BITs that were being rolled out in the 1980s, and also French BITs, some of which are still in vogue. The second model, which we found, are PRPs which employed NAFTA Article 1106 detailed list approach, where they specifically set out a fairly precise list of 5, 7, or however many list of prohibited measures. And finally, one which draws on the WTO law. There are still some PRPs in force, including some recent ones, which does so by incorporating a list of prohibited mandatory measures that are listed in the WTO TRIMS agreement. So just to briefly give an example, on this slide in front of you is an open-ended PRP from a first-generation US BIT, being the US-Ukraine BIT. And the key language there is to look for the end where it says, which imposes any other similar requirements. As you can see, the language is open-ended, and even though it gave some examples of what are the performance requirements that the state shall not impose. It leaves it open that there may be other similar ones which it hasn't expressly mentioned. And the French BIT does something similar, as evidenced in the language near the end of its provision, referencing any other measures that have a similar effect. And out of the 206 IIAs with PRPs which we have surveyed, 86, so I guess 40% of them are open-ended PRPs. Moving on, the next approach is the NAFTA Article 1106 detailed list approach, which from our study, which we have commented on, is probably the currently prevailing one that's most popular amongst treaty drafters, and you can still see that approach in some of the recent complex trade and investment treaties, which Christophe mentioned, like the CPTPP, USMCA, and the RCEP. And what's characteristic in the language of that drafting is that it begins with some expression which says no party can impose any of the following requirements, and then proposes to list a list of measures, often drawn and commonly drawn from the list that Alex showed us earlier. And in the example of the NAFTA, we have 7 measures. And out of the 206 surveyed IIAs, which with PRPs which have been analyzed, 66 essentially follow the NAFTA detailed list approach. And it's worth noting that the NAFTA Article 1106 approach has actually been quite influential recently, and it's formed the basis of subsequent models, such as the Canada-Ukraine FIPA approach, which has a narrow list of prohibitions, and also the 2004 US model BIT, for example, which has the same list but tweaks the language of some of the requirements. And we've tabulated this into a pie chart showing the exact split of these various different approaches. And as you can see, the NAFTA approach, including the NAFTA itself, forms a minority amongst this figure, but it's worth bearing in mind that all these other approaches, which are listed in the this pie chart, are all basically derivations of the NAFTA approach. So it is the current prevailing model. And then there's the approach based on the WTO Terms Agreement, which simply does so by reference. Very briefly on advantage conditioning performance requirements, there are also 3 models. No express prohibitions, such as French BITs, the WTO Terms Agreement incorporation approach, and then also the NAFTA approach, which is a more restricted targeted list of prohibited measures. And just to focus on, in interest of time, the data conclusion that we drew, this is the split of approaches. So the vast majority apparently have no express prohibitions, but the NAFTA approach of a more targeted detailed list is somewhat close second. Now I'll pass the baton back to Alex to conclude on an issue. Yes.
If you could, right, because
Yeah.
we still have to speak.
Perfect. I'll keep it very short. I have the benefit of being able to rely on remarks that Christophe made a bit earlier today, and it's merely perhaps to draw attention on this aspect of a lot of these performance requirement prohibitions. A lot of them over time have evolved, and they went from very open-ended, simple 3-line type treaty provisions to complex 1-page, almost sometimes 2.5 page long provision with a lot of prohibitions. But then over time, the treaty drafters got more sophisticated, and they started creating exceptions, carve-outs, exclusions in many shapes and forms. And it's just essentially a call out to be aware and vigilant about this, because these carve-outs, exclusions, reservations can be either in the same treaty chapter, generally they are in a different treaty chapter, but also quite often they're in an annex or in a separate document that must accompany the annex. So the annex will often say, go see the list of reserved non-conforming measures, and you have to track that down on your own. And so it's just to point that out, that often reading the provision is not enough. You have to go and dig into the agreement and figure out when does it not apply. And so there are a lot of carve-outs. Some of them have to do with taxation measures, others government procurement, cultural industries, sensitive sectors that are entirely excluded, for instance, from the scope of a performance requirement prohibition, just one that sometimes happens, for example, the nuclear industry. You can also have carve-outs that favor ethnic or indigenous minorities, for example, where the state wants to reserve the ability to intervene economically to benefit or help these groups. So it's important to think about these carve-outs. And you have some surprising or strange ones sometimes. So for instance, the sector that deals with archaeological buildings or national treasures. And so it's just important to keep that in mind. And sometimes some of them are counterintuitive. And very briefly, for example, on taxation, some investment treaties or investment and trade agreements will say, except as provided, nothing applies to taxation measures. But then you keep reading in that chapter, and then eventually it will say the following provisions apply to taxation, and it's opting the performance requirement prohibition back in. So it's just a bit tricky, and there are some pitfalls as to scope and coverage. And these awards, Christophe helpfully mentioned them earlier, so I don't need to elaborate too much, other than to say that these provisions do have teeth. They do provide remedies to investors. They can seek and receive damages. And so that can be very helpful. It's not just a promise made in the air without any consequences. And on that note, I will conclude. Thank you very much.
Thank you very much, Alexander. And we have two speakers who came to London from other countries to comment on this paper and to share their own thoughts. The first speaker is Dr. Maria Folgestam-Agius, who is partner at Westberg and Partners in Stockholm. Her work focuses on international dispute settlement, public international law, but also business and human rights and other issues. She did her LLM and doctorate at Uppsala University, and then worked for a number of years with a law firm in London before going back to Sweden. And Professor Erik de Brabander is a professor of law, of international law at Leiden University, and he is also a practitioner practicing law at DMDB Law. He is a chair of International Dispute Settlement and director of Grotius Center for International Legal Studies. And he spent over 16 years at Leiden Law School. And he studied law at Ghent University and the University of Geneva. And he also actively participates in the Working Group 3 meetings, UNSTRA Working Group 3. If you could limit your remarks to 10 minutes each, that would be great. Thank you.
Thank you, Jarek. I'll try to be as brief as possible. This is, of course, a very hefty report with a lot of information packed into it. I also want to start by saying, first of all, thank you so much for entrusting us to review this. I'm sure I speak also for Eric that it's always an honor and a privilege to have that kind of assignment to deal with someone's baby in that way. I want to start out by saying that I think that this is a very impressive piece of empirical research. Anyone who's ever tried their hand at anything empirical knows how difficult and time-consuming it is. I also think it's very topical, as was acknowledged in the IMF working paper that the authors alluded to in their presentation. There isn't that much literature on systematically documenting the industrial policy tools that states seem to be employing with increasing frequency in the present day. And I think, in my interpretation, this study in a way starts at the other end, documenting not so much the policies implemented by states, so much as the policy space that states sets for themselves in this area when entering into commitments with respect to foreign investors. This is what Christophe was talking about earlier. And if these two data sets could come together, I think that could provide for really powerful data. I also want to tip my hat to all of the authors for taking on a very complicated topic. This is a field that does not only require an understanding of investment law, but also of international trade law and also of international trade practice. And as I said, the empirical approach requires a methodological rigor and tenacity that is really impressive. As a former colleague of Christoph's and of Alexandre's, I know very well their respective backgrounds being a sort of dual trade and investment lawyers. And I expect Michael is also well versed in the topic by now. So I think this gives the study good credibility. And I think this also shows in the report how it's researched and presented. As for my remarks today as a reviewer, I find that one always plays a bit of catch up with the authors. It's as a reviewer, you do not have the time and luxury to dive into the materials to the same extent. So the authors are usually the true experts on the topic. And at least speaking for myself, I think that conventional truth applies here as well. On the other hand, as a reviewer, you have the advantage of someone else sorting and digesting and nicely wrapping up this material for you. So that gives you an opportunity to perhaps annoyingly so focus on the gaps and focus on the further implications, including ones that for very legitimate reasons may have been cut out of the scope. Of course, the study of this format cannot address every single possible aspect. And at 45 pages, I think this is a very digestible and manageable product. So kudos for making it so. I just want to share in my remarks a couple of thoughts that came to me while I was working on reviewing this study. There are plenty of points that one could take up, but we want to have some time for the Q&A, so I'm just going to pick a couple. My first question goes to methodology, and that is perhaps a somewhat provocative thought. What can we really take away from this impressive investigation? There seems to be ample data to extrapolate and make some educated assumptions about the commonality of PRP clauses, their functions, states' motivations for putting them in. And it's certainly possible to construct the typology that you aimed to do. And I think in that respect, this study is a great success. But, and as I also have discussed with the authors in the context of my review, the selection of states chosen here is not random. It's based on the fact that these states have taken active stances on this issue, either by insisting on the inclusion of PRPs or by resisting it. And in this sense, the sample may be skewed. On the other hand, with the large volume of treaties reviewed, I think you do have a chance here of catching also the large sample of states that have at the very least accepted the inclusion of such clauses. So not a huge methodological point, but nevertheless. A more fundamental query that I have is whether one can assume that the precise formulation of investment treaties is really given such great attention when it comes down to it. Of course, this may be different from state to state. The Canadian Trade Law Bureau, where both Christoph and Alexander worked, is surely an example of a very highly specialized governmental department dealing with these issues. But I know anecdotally of treaty text being suggested or accepted by generalist diplomats who are given this portfolio as part of a rotation. And they are basically learning the ropes as they engage in negotiations, sometimes dealing with what might be poorly understood model treaties or templates that are being handed to them. I think we have a full range of experiences here. And I've also heard it said that sometimes investment protection agreements are seen as very undramatic treaties that are being proposed in the context of state visits, more because it's considered to be an easy deliverable to get something out of the visit. So the study indeed seems to confirm that many governments take, if you will, a shortcut, and they rely on previous treaty texts, as you have traced so much of this language back to the NAFTA. But we do not know very much about the basis on which they decide to do so. I know that, Alexandra, you mentioned that there are some countries that will have a documented process for this and some countries will not. So we don't really know whether this was a carefully considered choice or not. And this is, of course, not a question just for this empirical treaty review, but for all treaty reviews. I had some very disconcerting discussions with government officials as I was doing a similar project on my own on a much lesser scale. And this makes me think of a quote from a Swedish 17th century statesman, Axel Oxenstierna. He was sending his son as a delegate to the treaty negotiations in Westphalia, and the young man was a bit nervous. And Axel Oxenstierna wrote to him with a rhetorical question, "Do you not know, my son, with how little wisdom the world is governed?" Seemingly important choices may sometimes be haphazard or followed by chance or routine. That said, I think the study does reveal a certain pattern of behavior. One interesting aspect that I think the authors convincingly explain is how PRPs sit in relation to trade policy, trade liberalization, and globalization trends that have perhaps come and gone. And they explain in this study how there was a convergence in the space of performance requirements where multinational corporations diversified to operate on a global market through both cross-border sale and cross-border investment. And I think that's a very compelling sort of storytelling of where we come from with this particular, as Alex mentioned, a hybrid form of investment protection. One can question, of course, whether this trade liberalization is still the overarching narrative of our time. The current inertia of the WTO would seem to suggest that it isn't. And Alexandra similarly noted in an email exchange that we had following on my review that PRPs could be less popular clauses in the future, or at least be accompanied by these carve-outs and exceptions that we have talked about because of the resurgence of an asserted right of states to regulate their affairs. But he, and I think correctly, also noted that when we see these more carve-outs, that could also be the increasing treaty drafting sophistication, if you would consider it to be sophistication to put a lot of stuff in various annexes that you need to go and find at great cost of time. I think one other issue that I would like to discuss is how this relates to the underpinning reasons of why we want to encourage foreign direct investment and what we expect it to do for capital importing and capital exporting states, respectively. Is it fair for developing states to expect that foreign investments will help boost their national economies by increasing the demand for local content that forms part of the value chain? Those tribunals that have required a protected investment to contribute to the host state's development might be minded to agree to that. Industrial policy tools that could qualify as PRPs can also be motivated not just by objectives relating to strategic competitiveness, but as you noted, also to objectives related to supply resilience, climate change mitigation, security concerns. And the corresponding discussion in the study confirms that a number of states have indeed put in place these exceptions and carve-outs. You have examples of the protection of public order and morals, protection of human, animal, or plant life or health, ensuring access to products in short supply, preferential tariffs, and so forth. And this corresponds with some of the trends that we see in current approaches to foreign investment. In other respects, states are revising their treaties to preserve policy space to such social responsibility issues, also in respect with other clauses, FET and so on. Security concerns are addressed through investment screening. In the field of supply resilience, you have the enactment of directives for corporate sustainability due diligence that will require companies to take a much closer look at their supply chains. And many of these measures were originally formed as part of a package of measures responding to supply chain resilience issues following the COVID-19 pandemic. So it's not just in sort of an altruistic human rights and ESG push. And it doesn't seem too far-fetched to assume that such measures could compel companies to look for ways to shorten or simplify their supply chains, as you touched upon, by de-risking, onshoring, friendshoring, and so on, even where more global sourcing policies could be more economical. So the question is whether such measures could be regarded as performance requirements and come within the prohibition under certain of these treaties. And this seems to turn on the discussion that you have regarding the Lemire case, as discussed in the study, regarding whether or not a performance requirement must be an explicit trade measure, or whether a PRP can be engaged by a measure that indirectly carries that effect, although the stated objective is different, and also on of course, the nature of the carve-outs. You even mentioned in the study that there might be some treaties that have a specific carve-out for performance requirements necessary to comply with EU rules. I mean, it would be interesting to see where that takes us. I will hand over to Eric there, and thank you so much.
Thank you very much.
Thank you.
Thank you.
Wonder what he's also read at the PhD on it. Maybe we should.
Are we okay with that? Okay.
No, doctor.
Okay, so thanks, Maria. Thanks to Christoph, Michael, and Alexandre for having invited me, and many thanks, of course, to Jarek for having co-hosted this event. I was also very happy to have been asked to review the first draft of this study, which I find extremely interesting. It's an impressive work, I think, that you have done. Sorry, Maria already explained it's quite some. It takes quite some time, I think, to venture into these questions. So what I wanted to do is not necessarily go back to, sorry, my comments on the paper, but maybe give some more policy or overarching questions on why we're having this discussion here. And so let me start maybe by bringing us back to discussion in the 60s, 70s, 80s in the General Assembly, when we had big discussions on the role of transnational corporations more generally. And of course, Alexandre knows everything because he has written a PhD on the topic, and he's actually more the expert in the field than I am. But at that time, we had a discussion in the General Assembly on the permanent sovereignty of natural resources, the new international economic order, and the accompanying plan of action. And then when you look at these documents, what I find quite fascinating is that they were actually very favorable towards performance requirements. The plan of action, the program of action, sorry, accompanying the NEO Declaration in particular, had various provisions on transfer of technology, on the elimination of restrictive business practices, and on assistance in terms of transfer of technology and management skills to developing countries on equitable and favorable terms. So you had a very favorable approach towards performance requirements. You then also had the famous United Nations Commission on transnational corporations, which came up with a draft that, of course, never was adopted at the end, but it's an interesting draft, so I will nonetheless mention it. The draft contains a whole series of provisions on performance requirements. I have a couple of them listed here. I'll not discuss all of them because Jarek would not be very happy if I would do so. But we have an article on balance of payments. We have an article where it says that corporations should contribute to the promotion of exports and the diversification of exports in the countries where they operate, to an increased utilization of goods, services, and other resources which are available in these countries. We have the idea that corporations should not impose restrictions on their entities that operate in the host market beyond generally accepted commercial practices, but also in light of the obligations imposed by the state, specifically in the state. So all these discussions, of course, we know have not yielded any, I would say, concrete outcome in terms of having resulted in adoption of these draft articles. They're still there. They form the basis for the subsequent discussions on the famous multilateral agreements, which also, of course, never materialized. But what is interesting is, of course, that in parallel to these discussions, we had the development of the BITs, and that's where I come to the, I would say, perhaps more investment-related questions. That is the US model BIT of 1981, which was, of course, very important, as was also mentioned in the report, but also I looked it up again, is discussed in Alexandre in his PhD, which was published also, by the way, with an absolute open-ended, as was discussed, prohibition of performance requirements. So you had this sort of paradox of the G77 and many developing countries trying to negotiate and agree on imposing performance requirements. And at the same time, you had the first model BIT of the US, 1981, which was actually having a completely open-ended prohibition of performance requirements. So we have and Christoph also mentioned that there's, of course, a cyclical evolution in how one deals with these questions. And they, of course, also always relate to the situation of the economy more generally. And I'm happy that it was also mentioned that there was an influence of the financial crisis, of the COVID pandemic. And we're seeing again here also, as was discussed, a sort of return of protectionist measures and hence also performance requirements. What I want to mention, nonetheless, is a couple of additional considerations. I think one of the reasons in the 60s, when states, developing countries mostly were imposing performance requirements, it had also to do with the fact that at that time they had mostly rather restrictive legislation, right? So there was an idea that by imposing performance requirements and leaving them out of those restrictive regulations in the state themselves, you would actually already, to a certain extent, obtain some liberalization, which is a bit counterintuitive. But the idea was, well, if we restrict, we limit the very restrictive practices and legislation and regulation in the states, and we look at specifically each investment, we open ourselves up to foreign investment. Now, we know in the end that this was completely abandoned in the sense that you had this move to liberalization that was discussed a couple of times, mostly because performance requirements were also not necessarily considered to be very efficient in obtaining or in meeting the objective of the measure. So there's a big discussion on whether the measure, and they were all discussed, are actually the best way to achieve the objective. So that's a big question that's still out there. It's not necessarily guaranteed. And there's a huge distortive effect on trade generally, of course. And this is one of the reasons why the US, amongst others, was also heavily pushing for the regulation of these measures, and which resulted in the Uruguay round and the TRIMS agreement, which is a bit more discussed in the reports. One of the comments I had, we're dealing here with things that, as Maria said, are legally quite technical, because they don't necessarily relate to the core, I would say, principles of investment law that we know. They are imported from trade law, and hence they sort of operate on a different level. They're very much related to trade, they're very much related to economics, and not necessarily very similar to fair and equitable treatment, for example, as we all know. Now, let me then conclude with one additional point, is that we're actually, if we look at why should we actually have this discussion, well, I think the main point that was made earlier on by Alexandre will indeed probably be seeing cases. There are not many cases so far, and many of the cases that discuss this also related to connected claims. So the PRP was not the main or only claim, right? So there were various claims. I think mobile is perhaps an exception, exactly. So we're seeing probably a revival of these protection measures, and hence possibly also a new series of cases. But what I also find interesting is that you see also a tendency to include, again, performance requirements. And I take one example, that is the Pan-African Investment Code, which is, of course, a sort of model treaty for Africa. It started differently. It started as a real code or Pan-African Investment Treaty, and it sort of evolved to a draft model. The Pan-African Investment Code actually has a provision on performance requirements and explicitly authorizing performance requirements. And the idea there, and I've had various discussions with colleagues involved in there, is that it's the same idea of the 60s and the 70s. And that's why I started with that. It's the idea that developing countries still want to make sure that there is a benefit to the development of the state, the population, its economy, that is not necessarily identical to the benefits the investor gets, right? So you see a return of this. Now, the Pan-African Investment Code is, as I said, a model. We'll have to wait and see what happens. And one of the big questions, of course, again, are they efficient? There are various research being done on this, and it's not conclusive. And secondly, and that's of course very different, so that's why I'm not necessarily convinced that states that would push for performance requirements will manage to do so, is that it also ties very much, is very much tied to the to competition, right? Imposing performance requirements works better if you're in a better bargaining position as a state, right? So the more liberalization you have, the more competition there is for investment, the less likely you will also be able to impose performance requirements as a state. So I think this is an evolution, and we'll have to wait and see what states will do in their future treaties. So I will stop here, but I want to again congratulate you on this work. And again, I didn't really discuss in detail the work that has been done. I would really encourage everyone to read it. It's excellent for practitioners, for academics, for state officials. And if you need even more, then there's always Alexandre's book, which will help you. So thank you.
Thank you so much. And I would like to thank all the speakers. And we still have around 15 minutes because we started a bit later. So what I would suggest is that we open the floor for one round of questions from the audience. Plus, I'm sure there will be things you want to say in response to those presentations. And then everyone will have, let's say, 3 to 4 minutes to respond. So are there any questions in the room? If you have a question, please raise your hand and introduce yourself. And if you don't have a question, that's also fine. It's a very technical area. And okay, and we are not going to record it, so I'm stopping the recording.